Good afternoon, and welcome back as the case may be. Thanks for coming to this panel. The topics that we're going to be talking about for the next hour, broadly defined, are issues where family law intersects immigration law. And so some of the topics are going to concern how family status affects immigration status. But we are also going to be talking about some other issues related particularly to children and young people and their immigration status. The way this is going to work is that I'm going to be asking some canned questions, carefully created questions to get the information out of our panelists at first, and they're going to talk, and then we will open it up for questions at the end. So let me begin. First of all, my name is Leslie Harris. I'm a law professor here at the University of Oregon, and I want to do an unscripted plug. If you're interested in the topics this panel is covering, you might want to go to the law school's website, the homepage. Across the top there are little buttons, and one of them says Family Law. If you click on Family Law and pull down to Child Advocacy Project and go onto the Child Advocacy Project page under Events, you will see something about children and immigration law reform. This was a program the Child Advocacy Project did in the fall, and this is information from that which covers many of these topics. It's got background information and so forth. So if you want additional information and some documentation, that might be a place for you to go. So let me introduce our panelists. From the far right, we first have John Almaguer, who is an attorney with the Idiart Law Group in Medford. He's an immigration attorney, a first-generation Mexican-American. He's worked for 10 years in immigration law, and his areas of expertise include family-based immigration, adjustment of status, consular processing, unlawful presence, waivers, V&K non-immigrant visas, and naturalization. Before coming to Medford, he was the senior supervising attorney at Catholic Charities of Oregon, where he developed expertise in most areas of immigration law and provided immigration law training sessions for the Medford and Portland offices of Catholic Charities. Next to him is Theresa Statler, who is in private practice for herself in Portland. She's practiced immigration law since 1994. She graduated from Lewis and Clark and is a member of the American Immigration Lawyers Association and the Oregon Women Lawyers. She just won the Gerald H. Robinson Excellence in Advocacy Award, which is awarded by the American Immigration Lawyers Association Oregon chapter. And she's been named an Oregon super lawyer for the last 3 years. She speaks English, Spanish, French, Italian, and probably other things too. Then we have Jennifer Doreen, who is an attorney with the Reynolds Law Firm in Corvallis. She also has been practicing immigration law for more than 10 years and has been in private immigration law practice since 2008. She's recently joined the Reynolds Law Firm, which focuses on family and business law. She does general immigration, including removal defense, business-based immigration, and family-based immigration. She earned a master's, Just skip the rest? Okay. And finally, we have Cheryl Holcomb Waxler, who is in her own practice as an immigration attorney in Portland. She went to the University of Washington, graduating in 2002, and belongs to the American Immigration Lawyers Association and Oregon Women Lawyers. She's been a U.S. citizen, but she has personal experience as an immigrant because she was born in Australia, grew up in England, and returned to the U.S. in 1993. And this experience of living as an expat has given her a passion for helping people with immigration issues. Okay. So, Theresa, I'd like to begin with you. Marriage is one of the most common paths for non-citizens to become residents and eventually citizens. Can you explain how spousal immigration works, please?
Sure. I do a lot of family-based immigration, so this is kind of the beat of my law practice. But in general, someone who is a U.S. citizen or a lawful permanent resident of the U.S., that means someone who holds a green card. They can petition for certain family members to obtain legal status, to become permanent residents themselves. And we'll kind of do the easy one first. A U.S. citizen, someone who was either born here or naturalized as a U.S. citizen, can petition for a spouse, a parent, or a minor child under 21. Those people are considered immediate relatives under the immigration law, and what that means is there is no waiting period or quota for the number of immigrants in that category that are admitted to the United States each year. So that's a real benefit. Someone who's a permanent resident, on the other hand, this is kind of goes to the last part of the question about waiting period. Someone who is a permanent resident can also petition for a spouse and a minor child. No parents in that type of a relationship. But the waiting period may last as long as 5 to 7 years, depending on what country your immigrant relative is from. So it is a definite plus, you can see, to be a U.S. citizen, and that's a reason many people naturalize, is that they can petition for their relatives, especially if those people are abroad, and they can come to the U.S. much quicker than, say, if you were only a permanent resident. In addition, U.S. citizens can also petition for a brother or sister. That is not open to permanent residents. They can also petition for married adult children and also single adult children over the age of 21. And those last three categories, the brother, sister, and the adult children categories, those also have a backlog or waiting time. In the case of a brother or sister, it might be as long as 14 years. I just filed a case last week where someone had filed for their brother who was in Mexico, and it's been about 14 years, and his number's finally up. So it's pretty amazing. You want to definitely, if you're advising people like this, or you're seeing people that need your help, you want to certainly tell them that that's possible for them to do, but you're not going to be able to have it happen soon. And the reason for the backlog is that Congress decides the number of immigrants in each category that are allowed to come to the United States each year. And with the exception of immediate relatives, the spouse, minor child, and parent of a U.S. citizen, those people are kind of out of the waiting line queue. The other people, Congress has decided how many in each category can immigrate each year. And so the backlog can be very long for countries from which we receive a lot of immigrants every year. And those, that would be China, India, Mexico, and I believe the Dominican Republic. Is that on there?
Yes.
Yes, and the Philippines. Those are the 5. So and then there's another category for all other countries. And you can look at this waiting line classification in the Department of State's Visa Bulletin. It's called the Visa Bulletin. It's published every month. You can go on the Department of State website.
They have it in their handout.
And you've got it in handout, I guess, apparently. So there you see the March visa numbers. It's always exciting around the 12th of the month when they publish this. It's around the 12th or 13th of the month. And so, for example, let's see. Look at that Mexico, 4th preference Mexico, January 22nd of 1996. So you can see that is about 15 years. So that was my client. His number came up. What that means is the day that your petition, the petitioner's request for his or her relative, the day it landed on the desk at Citizenship and Immigration Services, or back then, INS, the day it landed on the desk, January 22nd, 1996, those people are now ready to obtain their immigrant status. Many of those people have been living here in the U.S. illegally for all that time. The other kind of problem, and maybe somebody else can chime in on this, the kind of risk when you have these long waiting lines is the petitioner might pass away or die while your relative is waiting, and that can cause a lot of difficulties, a lot of hardship. So as far as the answer to the professor's question about cumbersome, I think it's the procedure is the same for everywhere in the world. I think the cumbersome and difficult part is the waiting line. And, you can see there, for example, with Category 2A, all chargeability areas, the date is January 1 of 2007. That's actually not so bad. Mexico is only January of 2006. That's 5 years. The other one is 4. That's still a long time, though, to be away from your spouse or minor children. So when there's talk about amending or changing the immigration laws to make them more friendly to families, keeping families together, this is what advocates for immigrants mean, doing away with these long waiting lines.
Thank you. So, John, do you want to talk about the specifics of the situation of spouses and having spouses being able to immigrate? How does spousal immigration work? How is our process different from other countries? And what happens if you've got domestic violence?
Okay, as to the law in other countries, I don't feel qualified to speak about that, but U.S. immigration law, U.S. immigration law is to unite families, not friends, and definitely not business associates. And so with marriage, that's a big fear that immigration has, is that people are abusing the system to be able to obtain legal status for a friend or in darker circumstances, a business acquaintance. So because they're concerned about marriage fraud, any person who obtains residency through marriage, who's been married for less than 2 years at the time that residency is granted, is given conditional residence status. They have the same rights and privileges of a permanent resident. They could work in the United States, they could travel in the United States, but one big caveat, that's only good for 2 years. Within 90 days of those 2 years expiring, you need to file another application, I-751, a petition to remove the condition from residency. I tell my clients who are familiar with the Mexican border, it's like the second stopway along the border. 60 miles in, we're going to check up to make sure, did you sneak past us? What that means is they're checking to see, is it a good faith marriage? What is a good faith marriage? Immigration doesn't get involved with what is love. God knows who can define that. But what immigration does is say, we want to see the intent to share a life together. Okay, what would this intent be? Well, do you file your taxes together? Do you live in the same house? Does your driver's license have the same address for each one of you? Do you have bills in both your names? Can you show us photographs? And please don't let those photographs be from around town, different clothing on the same day. I pulled out of that case really quick. So these are things that people need to submit. And as long as a marriage is a good faith marriage and they're still together 2 years down the road, it's an easy process. I tell clients it takes me about 15 minutes to do the form and 3 hours to run the photocopier, okay? Because I'm just doing copies of bills that they have. Letters, I don't like letters that much because, you get a letter from your mom's always going to lie. I want to see, what are you telling Uncle Sam? Show me your tax returns. I want to see a baby that was born, a house that's being paid off, a rental contract for an apartment. Every case is going to be different because all relationships are different. I once represented a couple of musicians, classical musicians, and they gave me a CD of Valentine music played together at a concert. And I said, my God, in Medford, when will I get this again? So I used it. I've used Habitat for Humanity. I had a couple who was working together in a house. I said, well, if you're willing to sweat together outside of a certain room, it must be a legitimate couple. So when they're together, it's a fairly easy process. When they're not together, then it gets tricky. Then that same application, the I-751, turns into a waiver. And we need to show that person has been a victim of abuse, mental cruelty, that the marriage was entered into good faith, but a divorce happened because, you know, we live in a country where over 51% of marriages end up in divorce. And someone else help me out here. Okay, so we've got the waiver for the divorce.
There's only three: good faith,
Okay.
for the battered, and extreme hard. I think there's six. There's something extreme.
You guys better into the microphones.
I think it's there's three: one for extreme hardship, one for good faith, but the marriage has been terminated, and the other one for extreme mental cruelty or battering.
Yes.
And so, really, if the parties are divorced, the one you want to use is the good faith waiver, that the parties intended to marry and at the time of the marriage was entered into, certainly intended that it would last forever. But life got in the way, but nonetheless, it was in good faith. Here's the bills in both names. Here's the photos. Here are all these things. So the immigrant, him or herself, is filing that.
Can I ask you something? I've always wondered about this. If you come in under the spousal waiver and you get divorced within that 2-year period, do you get to stay?
Well,
Or do you get sent back?
That's where it becomes a waiver. That's when the I-751, instead of being a petition, becomes a waiver. And what, as Theresa was saying, you're trying to prove that marriage was in good faith. So you're actually going back 2 years later. You're going back to the time before they married and during the life of the marriage and trying to reconstruct it. Sometimes it's easy, sometimes it's not. Right now I'm having to try to rely on affidavits from a lot of friends and family who can remember back in the day that they actually liked each other.
So what's the rationale for letting them stay? I can imagine some people saying, well, you don't have a family to reunify anymore. Send them back.
Well, that's why they've got the 2-year limitation. I guess the rationale is that if you've made it over the first hurdle, if you've made it past the border, you do have some interest in your permanent resident status, albeit that it's been for a very short period of time, 2 years. So in that period of time, you know, the person potentially has made some ties here, perhaps is working, and so the U.S. immigration laws give them, him or her, the opportunity to show, yes, I'm no longer married to the U.S. citizen, which was my main reason for coming here in the first place, but the marriage was entered into in good faith. I'd like you to at least look at this case and make a determination that I'm still nonetheless entitled to full permanent resident status.
And just to wrap up the question on the VAWA issue, because I want to make sure that yes, it's the Violence Against Women's Act. So it's for domestic violence situations, because what we've talked about thus far has been situations where the marriage was at least decent enough to get to the point where they filed an application and obtained the residency.
And they had bills together.
And they had bills together. But what happens in the situation where an application is not filed or an application is withdrawn? The immigration process, it can be an occasion for great abuse. It can be a power play over that person, the immigrant coming in. And so you have, unfortunately, situations where you have the U.S. citizen who is saying, you must do this or else I won't file an application for you. Or if you do that, I will withdraw my application. So it's used in a way to keep down a person. Congress, in one of its moments of enlightenment, said, you know what, this isn't good. We don't want people to stay in dangerous situations, risk their lives simply for an immigration benefit. So if you were married to a U.S. citizen or an LPR, lawful permanent resident, and you are a victim of domestic violence, which is psychological or emotional abuse, then we will let you either continue that application on your own or to file that application from the beginning, so self-petition. There are going to be other people on this panel, and I think Cheryl does a bit with VAWA, so I'm not going to act like I'm an expert here, but what I will say is that it's important to know that these safeguards do exist for people. Now, for people who don't have the privilege or fortune of being married to a U.S. citizen or an LPR, there's also a U visa, which is available for victims of certain crimes. So that would be the catch-all, if you will, for a person who is a victim of domestic violence, but the perpetrator is not a U.S. citizen or an LPR or married to them. It's pretty complicated. You need to get a certification from law enforcement that you're helping in prosecuting the case. But those things do exist. So those are, I think, some hopeful things that we have in our system to protect people from being abused.
Sherilyn, would you like to say any more about the FALA? Would you like to add anything?
I don't think so, not
Okay.
at the moment.
Okay.
I probably will. So.
Okay. Jennifer, in Oregon, same-sex couples can enter into a domestic partnership, which under state law gives them all the legal rights and duties that state law can give to married people, and that's also possible in Washington and California, and in some states, same-sex couples can even get married. Do at least same-sex couples who enter into those relationships have the same kind of immigration rights that opposite-sex couples who are married do?
The short answer is no. Immigration law is federal law, and in most cases, the federal immigration law gives full faith and credit to state family law orders. However, DOMA, the Defense of Marriage Act, is a federal law which prohibits the federal government from recognizing same-sex marriages, even if they're recognized in the state where the person was married. So normally, as we've talked about in immigration, if you're married, if you're legally married to someone and your marriage is legally recognized in the state in which you were married, then the U.S. government will recognize that marriage for the purposes of granting immigration benefits, except in same-sex marriages because of DOMA, which prohibits the federal government from giving those marriages full faith and credit. So I'm sure everybody here has had the same experience. You have same-sex partners who are interested, one of whom is not a U.S. citizen, who is interested in receiving immigration benefits. And the short answer is they can't receive immigration benefits as the spouse of a U.S. citizen. Instead, you really have to try to find some other route for that person to gain legal status in the U.S., whether that be through an employer or other routes that may be available, but the route of being a same-sex spouse is not available. I'll leave it there.
I wanted to add something about that. You might have all heard the last couple of days that President Obama and Attorney General Holder have stated that the administration is no longer going to defend, I thought this was good, defend the Defense of Marriage Act, which is the one, defend DOMA. So when I heard that on the news a couple of days ago, I immediately thought to myself about all the same-sex couples that I've seen in my office over the years that have come to see me, and several of them married and under, the current state law of wherever it was they were married. And I was saying, I can't help you. So now I'm thinking, okay, when I say we, immigration advocates, immigration lawyers, we're going to have to find the dream couple that's going to take this case to the Supreme Court. It's going to, file an I-130 petition like we described for a spouse and have it be denied because under the DOMA, and then, you're going to have to litigate this, is what I'm saying. So I was thinking to myself, who's going to do that? Which one of my, me, my colleagues, I'm thinking of all the people I know, and what kind of dream couple are we going to get that's going to take this up. I'm also reading right now the great book by Jeffrey Toobin called The Nine, about the Supreme Court. I don't know if anybody's heard of that. So I'm right in the thick of that, and I'm thinking about presenting, this case is going to end up in front of the Supreme Court justices and which ones might go for it. But I just thought that was incredibly fortuitous for us on this panel that, 2 days ago this came out about DOMA, and I thought, wow, we have to bring that up.
That's just what I was going to ask.
One thing I also was going to bring up is just as a kind of a history of immigration, until very recently, having HIV infection made you ineligible for immigration benefits to the U.S. And so, that, I want to say, it's just a couple months ago. Was that November? I don't remember.
It was January of last year, actually.
Seems like that was just recently changed, and that, immigration law is not really fast-moving on the social
We're a little
front.
behind the times.
Yeah.
And just a historical note, I think homosexuality was considered a mental illness, which was a reason to deny people entry into the United States several years ago. So we're slowly but surely making some strides in the right direction.
So I have one last question about family status, and I think I'll ask you, John. What about the ability of adult children to petition for the immigration of their non-citizen parents? And what if you have minor children? I know there's all this mythology about children being born in the United States and then being the anchor babies that can get their parents in. Can minor children petition for their parents to come in at all? Which I think the answer is no. And then what about adult children bringing their parents in?
Okay, I wrote, and I was told by my wife, no one can see this anyway, so you'll just have to take it on faith, that I wrote down the different relations that can apply for people. So what we have are the immediate relatives. The immediate relatives of U.S. citizens, as Theresa said, are people who don't fall into a family preference system, this visa bulletin. They're not falling in this long line. They're just falling in a moderate line. Those are spouses of U.S. citizens, they are parents of U.S. citizens, and they are children under 21 single of a U.S. citizen. Then you fall into the preference category, but we're talking specifically about a child, because we see a U.S. citizen could apply for their parent. As we know, that child needs to be 21 years of age to be able to put in an application for its parent. So that myth about they just come across the border and they have a child and they could stay, well, kind of, 21 years later. And then there's something else that makes that almost impossible. There are bars to unlawful presence. So if you see, I won't go into it because I want to conserve time for other questions, but in the handout, you do have the processing for adjustment of status. Adjustment of status is what you do when you're becoming a U.S. or lawful permanent resident within the United States. I kind of walk you through that. And then consular processing, which you'll see the big difference in how easy it is to fix in the United States versus having to leave to your country. So I think there's like 4 steps versus 16 steps for the adjustment of status that are consular processing, I should say. But if you look at the consular processing, you will see that a big obstacle is these bars to unlawful presence. Unlawful presence started in April of '97. Once you've hit the age of 18 for most purposes, if you've been in this country, I'll just go to the one that hits everyone. If you've been in this country for 1 year or more of unlawful presence, and you voluntarily depart, so that could be going to Mexico because you want to go for the holidays. That could be because a ICE officer detains you, processes you, and sends you out of the country. It could be because you go to Ciudad Juarez for your interview at the consulate for an immigrant visa to come into the United States. If you have more than 1 year of unlawful presence and you voluntarily depart, you're inadmissible. You can't come back for 10 years. It gets worse, but we'll just stick on that for right now. That's bad enough. The waiver is based on the extreme hardship that a qualifying relative will suffer. Qualifying relative for this purpose are only a U.S. citizen or lawful permanent resident, parent, or spouse. So what that means is if I have a 21-year-old client, and I've had this happen a lot, hey, you know what, I'm 21, I'd like to fix for my mom now. Okay, great. Where's your mom? And I'm hoping that answer is Mexico. And I'm hoping that answers, and she's never been here.
She's been there 10 years.
Yes, or she's been in Mexico for 10 years since her last entrance. But usually, unfortunately, the answer is, oh, she's here in the United States. How did she enter? She entered unlawfully. Okay, well, technically you can file an application, and if you look at that consular processing chart that I put out for you, they'll go through all those steps. They'll take all your money, and then when you're down in Mexico, they say, hey, you know what? You've triggered the 10-year bar. Oh, yeah, pero mi hija me puede arreglar. My daughter could put in a waiver for me. No, she can't. Only it's a parent or a spouse, not a child at any age. So if that parent leaves the United States, they're not coming back for 10 years. There's no waiver available to them. I don't care how good that waiver is, they're not even going to look at it. So what ends up happening in these cases is although that U.S. citizen child can theoretically put in an application, I'm not filing it for them because in about 10 to 15 months' time, that parent is going to have to leave the border, cross the border, and they're not coming back for a decade. So that whole myth about a U.S. citizen child being able to bring people over like crazy it's a myth. And also, the relations here show that you can't be putting in applications for your cousins and for your friends. It's a very limited amount of people you can put applications in for. So.
So before we talk about kids and adoption, we've all heard of the DREAM Act, and we've heard about its effect on young people and higher education, but it's also got some effects potentially on these family rules. Could you tell us about that, Cheryl?
Certainly. Has everybody heard of the DREAM Act? Okay. I'm seeing lots of yes. Okay. So, were the DREAM Act to pass, and of course right now what would actually pass, nobody knows. We have a version of the DREAM Act that passed the House in December, was it? Mm-hmm. And then didn't move forward in the Senate. We like to say it didn't move forward in the Senate rather than it failed, because they didn't even vote on the DREAM Act. They just voted to not consider the DREAM Act at that time. So we don't know exactly what a version of the DREAM Act that actually passes would even look like. We have some idea based on the various versions that have been around since 2001 until the most recent version, which included a number of compromises, which interestingly would leave out some of the people who originally started working on the DREAM Act because they'd be too old. But should the DREAM Act pass and people be eligible to get residency through status and then ultimately residency through the DREAM Act, they would most likely have a very long wait before they could become legal permanent residents. I can't remember the exact amount of time, but I think it's about 8 years.
It was
8 years before they can even apply. And they have to meet all sorts of conditions. They have to complete the schooling or military service that's required of them. So it's not until those DREAM candidates who get benefits under the DREAM Act become legal permanent residents that they would have the ability to petition for any family members. And once you become a legal permanent resident, in normal circumstances, you have to wait another 5 years to become a U.S. citizen. There are exceptions if you're married to a U.S. citizen. So the vast majority of people who would benefit from the DREAM Act would not be looking at being able to petition for other family members for 13 years. Yeah.
When they would be the
if that.
Would be subject to the bar.
And yes, exactly. And then the family would be subject to bars. I mean, realistically, it's no help at all. And a lot of the reality of this situation is many dreamers come from mixed families where there's a number of U.S. citizen children or a U.S. citizen sibling, or there's a lot of dreamers who have parents who have status and children who have status, and so the DREAM Act is not going to speed up the process for the vast majority of people. I think. Does everyone agree with that? Mm-hmm. Yeah. So, and part of the question was, are there any additional restrictions on DREAM Act candidates who, if it ever passes, sponsoring other people? None that I've heard of, but obviously it's not exactly simple or easy.
So Jennifer, the other big familial relationship involving some family members being citizens and others not, that is complicated, is adoption, particularly where U.S. citizens or lawful permanent residents want to adopt a child from another country. Can you tell us how that works?
There's three main ways you can gain, or a child can gain legal status in the U.S. through adoption. And then for the sake of time, I'm going to. Oftentimes, people believe that if they have a family member who a minor family member, and they would like to just adopt that child, so that child can. If the adult is a U.S. citizen, they'd like to just adopt their family member, so that it'll be easy for that family member to get legal status in the U.S. as their child. It's actually quite complicated. The two main complications are the Hague Convention, which was actually adopted by the U.S. in order to protect children, and does a lot of good things to protect children from human trafficking and international adoptions. However, if the U.S. is a member of the Hague Convention, and if the child is a citizen or a resident, habitual resident in a country that is also a member of the Hague Convention, you have to go through the Hague procedures in order for that child to get legal status in the U.S. The Hague procedures are a very, very lockstep procedural process, and oftentimes if you don't know from the very beginning that you need a Hague adoption, you can your adoption may not meet the it may not meet all the requirements, and your child, if they don't meet all of the Hague adoption requirements before they're 16, they will not be able to get any legal status through adoption. So that's one complication. The other complication is if a child is adopted by a family member, or not even a family member, if the parents are still alive, generally speaking, immigration is going to give full faith and credit to adoptions that are legally completed in the country where the child is resident, But if the family members are still alive, immigration can look behind an adoption, even if it's a fully legal adoption. And if they believe that that adoption was completed just for the purposes of immigration benefits, they will deny the application. So even if you have a family member who's willing to adopt a child, the child is legally adopted after all the expense, and it's not an easy process, all of the extreme difficulty of getting that process completed. In the end, immigration, if the child's parents are still alive, is likely to deny that application because they're going to believe that it's just completed just for the purpose of giving the child immigration benefits in the U.S. So the short answer is adoption is very complicated and is highly unlikely to give a child immigration benefits in the U.S. unless it's an adoption for a child who's legitimately an orphan, or a child who's legitimately in a foster care situation in their home country.
Another scenario in which the immigration status of children can be very complicated is when you've got a child who is living in the United States who is who basically loses their parents, not through death, but the parents might be picked up by immigration, the parents might go to prison, any number of sort of things. So the kid essentially is winding up in the child welfare system in one way or another. What happens to those children, and particularly can you also talk about what difference it makes if the child, him or herself, is or is not a citizen or lawful permanent resident?
If a child is in the U.S. is a U.S. citizen, I mean, they're going to have the benefits of, the child, all the DHS programs that a citizen would have. Children who are not, who do not have legal status in the U.S., there is a program called the Special Immigrant Juvenile Program, and children who become wards of the state, I know there's another term, but who lose their parents can receive immigration benefits as a ward of the state, can gain residency in the U.S. Does that answer the question? Yeah.
What happens if a child is a U.S. citizen born in the United States, but that child's parents are not citizens and the parents are picked up by ICE and are deported? What happens to the child?
I'll take that one. I do a lot of removal defense. Well, it's usually a shock to people who don't know a lot about immigration law that we deport fathers and mothers of U.S. citizens every day in large numbers. So, every now and then you see an article in the paper about this, and it's a terrible thing, and it does tug at your heartstrings, but it happens. As Jennifer was saying, the U.S. citizen child has all the rights and benefits accorded to someone who is a U.S. citizen. The reality is, if that child is 3 years old and both of his parents are in the process of being removed to another country, the child's going to go with them. I've had this happen in some cases, and in the short term, you are often able to negotiate, let's say, a humane, quote-unquote, deportation of the parents if you have young or youngish U.S. citizen children. And what that means is sometimes they will let you, buy your own ticket and bring it in and show it to them, and everybody flies away, and the ICE officer waves bye-bye at PDX airport. That's a removal, just as if they were taking you in handcuffs on a government-issued aircraft. But that way the child can go with the parents. But you don't get any special credit or anything like that except in an informal way. But it happens a lot. And maybe John, you can talk a little bit about your experience.
Hey, so I just wanted to add something too. I think a lot of times people don't know, like when there were these raids happening, there's no protection for those U.S. citizen children. So hopefully somebody's going to pick up that child from school. But if not, it's family members scrambling around, or friends, or neighbors, or older siblings. Basically, hopefully that child has a way from home from school, or wherever they're at. And there's a really shocking story. I think it's out of Minnesota, or maybe it's Michigan. But an immigrant was put in immigration detention, which immigrants who are found are often put in immigration detention, especially as the result of raids. This is what happened in this case. And she had a child, a U.S. citizen infant child, who was taken in by a family member or somebody close to her who couldn't care for that person, for the child. The child was then taken in by a church, given up for adoption. And so now there's a very big legal battle. I think the child is E3.
Yeah, and they're trying to get him back.
And the mom, so now there's this couple who have adopted this U.S. citizen child and who think, you know, how could this child has never known anybody else, but the mother, her rights were not protected. She was in immigration detention and she was not given a lawyer. There was no lawyer for her immigration case. There was no lawyer for the termination of her parental rights. And now, of course, I mean, the judge, I read about the judge's decision in the case, and he said, you know, that it was such a horrible position to have to be, as this child is 3 years old, there's no good way. So, I mean, that's just a stark example of how a U.S. citizen's child, I mean, there's no way to solve that for that child. And the fact that mother was not given an attorney to help her protect her parental rights is what created this situation to be what it is today, that's an ongoing battle. I think the judge sent it back to determine whether the termination of parental rights was appropriate. So the biological mother sort of won one step of it, but it's not resolved. So it's a good example of...
There's some people trying to do something a little proactively and trying to set up some types of power of attorney guardianships for if this situation were to take place. Another part of that is once a child leaves the United States, so a U.S. citizen, I've actually had that child come back 24 years later and ironically was able to petition his parents, petition his wife, but when he tried to get a U.S. passport, it took us a year and 92 documents to prove that this U.S. citizen was actually the owner of his birth certificate. So when I have a situation where someone is going to be deported and they're trying to figure out what to do with the children, my advice to them is always to get a U.S. passport for that child before that child leaves. So if you have a photograph with the name and the information, so you have a way of linking that birth certificate to that U.S. citizen child. Because if you're living most of your life in a foreign country, you may not be able to speak English when you come back. And so they're saying, why does a U.S. citizen not know how to speak English?
Yeah, because you never know, as he was saying, 24 years later, it's a lot better to have an old expired passport with a little baby photograph on it that says born in Oregon than just an old wrinkled piece of paper that's been in a shoebox.
Well, you can renew it in the consulate abroad.
Yes, but they probably haven't used it in the meantime. But I wanted to put in, I spend a lot of my time fighting immigration and customs enforcement in the removal proceedings, but I didn't want to put in a small plug for them in the Portland office in that most of the time, and Cheryl, and you can correct me if I'm wrong, but I believe most of the time here when they arrest and write up a woman with small children and place her into removal proceedings, if she is a parent of one or more small children, they do not detain her in the immigration detention facility up in Tacoma, which is where everyone in Pacific Northwest goes. They usually release those women so that they can care for these children and await their removal proceedings here in Portland, and that is a real benefit. So I'm hopeful that the situation that she was describing with somebody, if there's another raid, God forbid, in Portland, if this kind of a thing happens, that we wouldn't be seeing that.
Thank you. And from my children-in-law perspective, I will say, and whatever you do, try to keep the kids out of DHS and try to get them with family members, because when they go into DHS custody and they go down the path of the parents really likely to land in the pot of termination of parental rights because not being able to reunify with the child. And they'll get a lawyer, but there's no defense. So get the kids to the family members. We have a few more minutes, and I think now we will turn to perhaps more hopeful topics. What do you all see in the way of the potential for immigration reform generally, and then particularly So this was not a good topic? I said here I was supposed to ask this. Viable options. What do you see as viable options for comprehensive immigration reform? Okay, you talk about the DREAM Act.
Well, okay, because, so obviously we're not super hopeful about the immediate short-term prospects of comprehensive immigration reform, but the DREAM Act advocacy going on right now all around the country. I mean, the DREAM Act passed in the House. That's a really, really big deal. It's really exciting. Although it was hard to stay excited for long, obviously. But it is, the advocacy is going on around the country, and it continues to go on. Anybody who's interested, this is like the youth movement that's going on right now. It is very powerful. A lot of things are happening. There's actually a conference in Memphis next week, I think, the beginning of March. They're organizing a national Coming Out of the Shadows Day and week. Dreamers, these are young people who are attending college or who want to attend college. And they're tired of having to live in the shadows, and they're coming out. So, and amazing young people. So if you're interested in that area of immigration law, it's certainly a good movement to be involved in. Oregon is very involved. Just because we're a small state doesn't mean that we're not doing an awful lot. There's a group, Oregon Dreamers, and a big movement and a huge national movement. So there's a lot to be hopeful that is eventually going to be successful. And Dreamers, I think, will continue to advocate not only for themselves but their communities whenever, and whether the DREAM Act passes or not. This is a movement that's not going away. So. And it's hopeful.
I have some, perhaps not as hopeful, but perhaps more pragmatic. Is there's two House bills in Oregon that are would dramatically affect immigrants' rights in Oregon as well, and that's a tuition equity bill. Do you know the House?
Yes, I do. It is, I believe, Senate Bill 742. Yes, it is.
And 849, I think.
So you have them here. Do you want to talk about them?
Well, actually, that's on another panel, but I'll just briefly mention it. Senate Bill 742 is essentially, I call it a mini Oregon DREAM Act. It has the provisions that the federal DREAM Act had that would allow for in-state tuition for young people who did not have immigration status. And in a nutshell, the Oregon bill, which I believe is going to be discussed next week is it an education subcommittee?
Yeah. 1 p.m. Education Subcommittee is having a hearing on the tuition equity bill.
SB 742. And what it says is that a young person who attended high school or other public school in the state of Oregon for at least 3 years can obtain in-state tuition benefits. And the only other little string, which I'm sure would be happy to tie around themselves, is they have to agree to become a permanent resident or a citizen of the United States when they are able to do so.
And the other positive legislation is Senate Bill 845. It hasn't gone to committee yet, but that would allow for people who don't have legal status to get driver's licenses, which would be huge. I mean, that would be a huge change.
One of the ways a lot of people end up in removal is, they're oftentimes pulled over for driving without a license. And once you're pulled over by the police and they arrest you and they put you in jail, then oftentimes immigration gets involved. And so that's one of the most common ways that immigration interdicts. I don't know what the word is. People who are undocumented in the U.S. and puts them in removal proceedings. So having driver's licenses would be a big benefit to people.
It would also deplete the population of the state of Washington, which has grown tremendously because they still do give licenses.
You've got to wonder what that did for their congressional districts. Did they add a congressperson for the extra?
They pay a lot for vehicle registrations, I'm sure.
Well, we have a grand total of 2 whole minutes, so if anyone has a quick question. Yes, sir.
I practice immigration law, and I just have kind of a question I want to answer by maybe kind of recently, it seems like cases have been processing more faster, and I've been getting a sense that they may be preparing to make some type of change, maybe offer some type of amnesty, or kind of gearing up. Have any of you noticed that?
Let me repeat that just because I don't know if they're recording it. He says he has observed that cases seem to be being processed more quickly, and he's wondering if maybe there's some kind of gearing up for some kind of amnesty or something.
Well, I guess what I'd like to know is who is the proverbial they? Are you talking about Citizenship and Immigration Services? Who are you talking about?
As well as they just put another judge up in Portland. I know they've been needing one for a long time. And their case processing, it seems like almost across the board, has been taking place faster. I did some petitions that include change of status that have recent one just took just over 3 months.
That's standard in Portland. An adjustment of status is 3 months. But, the immigration fees for Citizenship and Immigration Service petitions and applications have increased twice in the last 4 years. So a lot. They've increased dramatically. So that's a lot of money, and the money was supposedly to go to hire staff to process said applications. So I guess we're getting what our money's worth. With regard to the immigration judge, that is part of the U.S. Department of Justice. That's a separate agency, and I think that's something completely separate.
I'm going to call this, and please join me in thanking our families.
Thank you very much. Sorry, I didn't mean to steal your No.
Okay. Well, good afternoon, everyone. My name is Margie Paris, and I'm very glad to welcome you to the criminal law and immigration law part of this wonderful symposium. I'm going to introduce our 4 panelists, and I'll do that all at one time so you know who's speaking, and then away we will go. And I believe, panelists, that what we've done is indicated some questions to you rather than ask you to prepare any organized remarks. We've got some questions, and we'll start that way. If this turns into a conversation, that is fine with me, and we'll just keep it going. My understanding was that this panel was supposed to run from 2 to 3. Does anybody know whether we have a panel bumping up against us at 3 o'clock? Yes, okay. So we will be good citizens and shut this one down right at 3 o'clock. Okay, so your wonderful panelists today, on your left is Mr. Ryan Bounds, who is an Assistant United States Attorney for the Department of Justice, which has exclusive responsibility for prosecuting violators of the nation's criminal immigration laws in federal court. And Mr. Bounds has coordinated the federal immigration docket for the U.S. Attorney's Office in the District of Oregon since 2010. He also served in the White House as Special Assistant to the President for Justice and Immigration Policy in 2008-2009. He served as the Chief Staff Officer on Immigration Policy in the Department of Justice during 2 Congresses, the 109th and the 110th, in their consideration of immigration reform legislation from 2005 to 2007. Prior to joining the Department of Justice, Mr. Bounds was a law clerk for the U.S. Court of Appeals for the Ninth Circuit, and he is a graduate of Yale Law School. Seated next to him is our alum, Oscar Garcia, who is an attorney in Portland. Mr. Garcia has been an attorney there since 1995. He's in private practice in the defense of criminal cases. He defends those cases in both state and federal courts throughout the state of Oregon. His office is located in Hillsborough. A large portion of his caseload comes from Spanish-speaking individuals. In addition to his criminal defense work, Oscar serves as an advisory attorney for the Consulate of Mexico in Portland on criminal law matters, and he also serves as the chairman-elect this year for the Oregon State Bar's Unlawful Practice of Law Committee. In January, we at the law school were very pleased when Mr. Garcia rejoined us to teach a January class on how to represent Spanish-speaking clients, and some of my current students have told me how much they've enjoyed my former students' teaching. Next to Mr. Garcia is Ryan Dibble, who is an attorney with the LA County District Attorney's Office. Obviously, that is in Los Angeles. He's been a deputy district attorney in that county since 2006. He currently carries a felony caseload in Long Beach. As a district attorney, he's prosecuted crimes ranging from petty theft and driving under the influence all the way to homicide. He has also prosecuted juvenile crimes. Today, a significant number of Mr. Dibble's cases involve immigration issues. He most frequently encounters immigration issues in his work through immigrant case filings, as well as through the negotiation of defendant plea bargains and the location of material witnesses for trial. While in law school at USC, he served as a summer intern for the United States Attorney's Office in Washington, D.C., where he assisted the Transnational Crimes Unit in the prosecution of immigration fraud. And then finally, to my immediate right is Joseph Justin Rollin, who calls himself JJ. He practices in Portland with the law offices of Joseph Justin Rollin. And his practice is in immigration work. He mainly helps non-citizens with criminal issues. He is the co-author of several books on immigration consequences of criminal activity, including The Criminal Defense of Immigrants, which is in its 4th edition. And he is the update editor for the treatise Immigration Law and the Family. With the Washington Defenders Immigration Project, he drafted the first comprehensive chart of immigration consequences of crimes for the state of Washington. Prior to entering private practice, he was an attorney advisor for the immigration courts under the Executive Office of Immigration Review. So please join me in welcoming these 4 very expert panelists. So I'm going to kick off with, and we're going to share microphones here and let us know if you have any problem hearing us. I'm going to kick off with a series of questions for, I guess I'll call them euphemistically, the 2 Ryans. They are also our 2 attorneys who are involved on the prosecution side. And I'll let you 2 kind of bat these back and forth depending on which one would like to answer them. So I'm going to start off with the Padilla case and ask one of you to describe that case's holding briefly, and then ask you, how do immigration consequences affect plea bargains at the federal and state level?
All right. So the Padilla case, in a nutshell, is just the Supreme Court's recent holding that it would be ineffective assistance of counsel for a defense counsel not to advise his client prior to undertaking a legal decision, particularly the entry of a plea, about the potential immigration consequences of the criminal prosecution he is facing. And more generally, that lawyers are expected to be sufficiently cognizant of immigration consequences when advising clients and will be evaluated in collateral attacks and prosecutions, as was the case in Padilla, on whether they have properly advised their clients of collateral immigration consequences. Was there a second part of the question?
No, that's the perfect answer to the first part. And then the second part is, in your experience in the federal courts, how has Padilla affected plea bargaining?
Well, I actually think that Oscar is a better person to answer this question. In my experience, a large proportion of the alien defendants we interact with in the federal system are aliens who have been previously removed, and so there's not a lot of Padilla consequence going on. They're already subject to removal. They're often already subject to an ICE detainer, and so there's really no ambiguity about what the immigration consequences of the pending proceeding are, because, of course, the outcome of the pending proceeding is largely irrelevant to the immigration consequences they're going to face. Merely having been found by law enforcement officials, they're going to be summarily removed because, at least for the last 14 years, the immigration authorities have had the administrative capacity just to reinstate an existing removal order. So there's no new process. If you are subject to a removal order and you're found in the United States, even after having been previously removed, they can just reinstate that old order and remove you. So in my experience, there's not a lot of federal consequence.
I could add on a little bit about that, is that federal prosecutions are usually very serious cases that involve, a lengthy investigation. If it's a drug case or some type of conspiracy case, it's been probably investigated for years and it's very well documented. So most of the people are looking, anywhere between, it could be a minimum of 10-year case or something. So really, a lot of times you're just kind of dealing for, you're going to negotiate, you're dealing for time. And the other issues are really not relevant because it's typically a charge there's just no relief typically for the nature of those charges, especially if they're drug cases. I've had some success in the past negotiate some cases in which involved extensive cooperation, which is what the United States Attorney's Office was very happy for, that a client of mine would be cooperating, providing information, and giving good information that led to some negotiations in terms of the charge. And I believe Theresa Statler is an immigration lawyer that I worked with on this case where it involved from a conspiracy case down to a misprision of felony type charge that helped. But that involved a lot of cooperation. So I think that at the federal level, there isn't a whole lot of charge bargaining or just consideration of the charge. I think it's going to probably require some type of cooperation where you're assisting the government. You might be able to get something. I think a lot of that is more so the charges is probably going to be on state court where there's probably little lower cases. They're not as serious. But I'll let Ryan address that case. But at the federal level, it's very rare to get any type of concessions from my experience without some type of cooperation agreement that involves with the government. So,
and just to add to that, I would also add that in the Padilla case, one of the key elements was that not only do defense attorneys actually have to give good advice when they advise on the immigration consequences, they also can't remain silent on the issue. And so they actually affirmatively have to give this advice when they're talking to their client and advising them on whether to take a plea deal. In California, it hasn't really affected anything in my experience. In California, there's Penal Code Section 1016.5, which requires that a court advise a defendant when his plea is being taken that he will be deported, will be denied reentry, and will be denied amnesty if he ever tries to come back. So the defendant's already going to be on notice. That's statutory. There was a case, In re Resendez, in California that already stood for the proposition that misadvice is a basis for an IAC claim, and a defendant can get a plea withdrawn on that basis. But it didn't address the silence issue if a defense attorney didn't advise and just chose not to go into that arena with him. And in that respect, Padilla does affect California, because if you read the Padilla opinion, it says it definitely calls into question that decision in California. But in terms of a practical impact, it isn't really that much because, as is pointed out in Padilla, the benefit of the bargain was to the defendant to take the deal in the first place. And so the only thing on a habeas petition when he's saying my counsel wasn't competent that he's going to get out of that is a trial. And he took the deal probably because the chips might have been stacked against him at the get-go. So, okay, then the state puts on its evidence that it had, and instead of getting the benefit of that bargain, the defendant's going to look at significant custody time. So the practical effect of it, I don't see too much of, and I'm not sure if that would ever come up. Maybe you guys have different experiences.
I think JJ has something from the working perspective, and then Oscar.
Well, actually, I'm going to start off with the California stuff. In addition to Resendez, there is also two other cases, Soriano and Bautista. And between the three of them, they pretty much covered the full spectrum of what Padilla holds. In California, under Bautista, there was a duty for counsel to I guess Soriano was a duty of counsel to investigate the immigration consequences. And under Bautista, there was a duty to defend an immigrant against the immigration consequences. So essentially, if the person knew that the crime that they were charged with and they might be pleading to would cause their deportation, it was up to the defense attorney to work with their client to try to come up with a solution that would not make them deportable. There's actually some argument between different attorneys across the country whether Padilla even goes quite that far. So to an extent, California is actually still broader in the rights that, the protections that immigrants have than other places in the country. As far as Oregon goes, Oregon and the majority of other states in the United States all have a statute just like the 1016.5 that he was talking about, in that the courts, not counsel, but the courts are required to give the immigration warnings that he stated. Unfortunately, the Oregon version of that is subject to the same 2-year statute of limitations as all other post-conviction relief, where in California, it's not subject to any limitations. So if somebody didn't receive that warning 10 years ago, they can still reopen their criminal case, and basically the charges come back and they get a second chance to negotiate a plea, hopefully that doesn't cause them immigration problems. In Oregon, if you've missed your 2-year statute of limitations, you're toast. So as far as criminal people in Oregon goes, it's really, really important to make sure that people know about that 2-year statute of limitations.
I could add a little to that. I mean, I think as a defense attorney, we sometimes clash with immigration attorneys, the advice. I know what would work in this case, but we're just a lot of times not able to get the prosecutor to give us that, and we're put in that situation. So what do we do? And either we take the plea because it's going to minimize potential prison time, or we just go to trial and see what happens, and then that can be appealed and there's an appellate record. But a lot of times, with the advice that I get when I work for an immigration lawyer, I try to get that, and I think what Padilla has done is it's highlighted that issue with a lot of the prosecutors I deal with. If it's a real issue now, or a legit issue that we need to discuss, that the U.S. Supreme Court is saying, whoa, wait a minute, this isn't a collateral, this is something we really have to discuss. So I think a lot of state prosecutors now understand that and are willing to work with that because of that, because they don't want a post-conviction case to come back, in their jurisdiction with that issue. So I think that it has created a good dialogue, and I've had some success with some of the prosecutors and depending on the nature of the case and working a charge in a way that's acceptable to working with an immigration lawyer. But it's just hard. It's very, very hard sometimes because a lot of times the prosecutors are not very sympathetic and they just won't do it. So that's where sometimes there could be a clash between us and the immigration lawyers.
So let me turn the focus just for a minute away from Padilla and the issue of collateral consequences to some of the other ways that immigration law and criminal law practices intersect. And my next question, I'll start again down at the end of the table there. How do immigration issues affect case planning? So, for example, do you have situations, and I'll maybe ask both prosecutors to address this, where the location of witnesses or the immigration status of witnesses affect how you try a case or what your planning is?
I'm sure the other Ryan will have a more interesting response to this than I do, because it seems to be much more of an issue along the southwest border, particularly in the material witness circumstances that they often confront there in immigration prosecutions. But in my experience, the primary relevance of a defendant's or a witness's immigration status is, well, the defendant's immigration status is different from a witness's immigration status. On the defense side, the government has a lot more leverage, of course, over a defendant who is charged with a variety of crimes and is subject to prosecution for immigration crimes. And actually, this is a fact of life that has been leveraged by the Department of Justice over the last few years to great effect, where they basically, the lowest hanging fruit felony charge that the Department of Justice can prosecute is the illegal reentry charge, which is where you've been removed from the United States, you may be found with a single dose of drugs, or you may be found with a lot of drugs. But the one thing that everyone in the room knows that you can be pegged with is the felony for illegally reentering the United States after having been removed. And that can get you up to 20 years in jail, so it's not chump change. And so that is sort of like, that's the starting point for negotiations. Now, we're required by Attorney General policy, and have been through many attorneys general, to charge all the readily provable offenses, the most serious versions of those offenses. And so it's not like we would disregard other offenses that we could prove in a federal case. But just having that immigration charge as a floor makes these cases different from cases that don't involve people who are confronting those consequences. When you're dealing with witnesses, there are a whole bunch of immigration benefits that are available to witnesses and victims of crime. And we heard a little bit about that in the last panel. And that actually can be very useful for purposes of getting witnesses to come forward, even though they naturally are concerned about interacting with law enforcement if they're not legally present because they're afraid that they may be removed. If there's some possibility of securing an immigration benefit, a U visa or something of that nature, then they may be willing to testify when they would otherwise just melt into the shadows. However, there's also the problem of appearing to offer benefit to a witness against a criminal defendant. You don't want to seem like you're buying testimony or something like that. So it can be complicated, but there's a substantial significance to the immigration situation a witness is confronting. The most significant, though, as a practical matter, is simply that they often are not willing to testify if they can possibly avoid it if they are worried about being deported.
Can I just add a quick story then? On a federal prosecution case where a lot of the witnesses they didn't have any charges. They were just holding them as material witnesses. So instead of holding them for 2 years, because the case went on for about 2 years, we did video depositions. So we all agreed that, hey, because they were going to be released to ICE and they were going to be deported, so, didn't really know what they knew or what to ask them, so it was kind of like a free-for-all. But, the feds don't really give us much information beforehand, so it's the way they play ball there. So, but we did video. It was a video record. We stipulated to it, and but that was just something I think that the prosecutor wasn't going to keep these 5 or so people in custody because they're witnesses as live. So we made this agreement. So I thought that was, I've never seen that before, but that was I think a good thing to do, and it worked out.
So there's a federal rule of criminal procedure that permits that where...
Well, it was, depositions. We just did depositions, and you might be able to add a little bit more to that, but...
Yeah, they'll just do cross-examined depositions, and that is admissible where the witness is unavailable. They do it, I think, often in reentry prosecutions federally along the southern border where you have a whole busload of people who are caught illegally entering the United States, and because a lot of them are sort of very small fish, they've never been convicted of any crime, the U.S. Attorney's Office along the southern border won't want to prosecute those individuals for a federal immigration charge, and instead, but they have to keep them available because otherwise the defendants that they do want to charge will claim, well, I was either kidnapped by the witness that you sent back across the border and is now no longer available, or he was the driver, or they'll have all sorts of claims that they want to be able to call the now absent witness to corroborate. And we're constitutionally required, of course, to make that testimony available. So in those circumstances where they anticipate prosecuting aliens for immigration crimes and they have to immediately deport a bunch of witnesses, they will do these video depositions.
And who cross-examines? Do you have the...
Panel attorneys.
The defense lawyer.
So you've already been appointed to represent...
Right, yeah, we'll be there, and the clients will be there, and there will be interpreters there. It's kind of like a little mini... It doesn't necessarily have to be in a courtroom. It could be in a conference room. We have video, they're videotaping everything, but, we just do the best. We try to get as much information, kind of figuring out, because we really don't know it. It may be really early in the case, and we don't really know what these people know. And I think it may be that they may not even use them as witnesses, but it's just, they have that testimony if it's necessary later on.
Ryan Dibble.
In L.A. County, obviously, every case that comes in, you wonder if you're going to have witnesses, and as opposed to the federal system, all of the stuff that we get almost is arrest generated. So the clock is ticking from the minute that the case comes in. There's a 48-hour window to file the case, and then within 10 court days you have a preliminary hearing. A lot of courthouses in L.A. County, if you don't have the live percipient witnesses present at that hearing, the case gets dismissed. Or we're unable to proceed. Other courthouses in California or in LA County, we use what's called Prop 115 testimony. At preliminary hearing, you can use hearsay from an officer from these witnesses. So it depends where you are. You need that witness right away, though, preferably. So our strategy with witnesses in terms of case planning, I think that's the chief issue, is getting witnesses to court. Is to involve them as early as possible with what we have in the office called the Victim Witness Assistance Program. And one of the things that office can do, in Long Beach we have 2 really good paralegals who help us get the paperwork started for a U visa, and that goes up higher in our office per policy to get those witnesses as victims and witnesses of crime the possibility of being able to remain here for cooperating with law enforcement. Of course, that's an area that's ripe for cross-examination when it gets into court. But victims and witnesses in California are already entitled. Victims are entitled to restitution and things like that. So in terms of being a prosecutor preparing for those types of questions coming up, very similar in the preparation. But I would definitely say that making sure that witnesses are in court and getting them involved with our victim-witness relations people is the key at filing. But just finding out from the filing detective if that's going to be an issue in the case, referring them to the paralegals that we have. And unfortunately, I'm actually handling an attempted murder case right now where it's coming back to court about every month for pre-trials, and there's a Mexican national who's a witness of mine. I have to keep having him ordered back to court, which is hugely inconvenient for him because I don't know if he's going to be around because I don't think his paperwork necessarily has gone through, and so I need to see his face because if I don't, then we have to get a bench warrant issued. Unfortunately, it's one of those unfortunate things just so that I can prove an attempted murder to get a dangerous person prosecuted for that crime. So there are a lot of things with case planning. I think most of it has to do with witness availability at the state level because the process moves so quickly from the time of the crime. The fact that a lot of these witnesses don't want anything to do with the police because they're afraid of getting deported.
Excuse me, sorry. Could I please ask the speakers to speak closer to the mics because we're having trouble picking it up for the webcast. Don't be shy about moving them closer to yourself too when you're speaking, especially in the middle and on the sides. That would be a great help. Thanks.
We'll move them around.
Thank you.
I wanted to ask Ryan Dibble specifically about a process in California that's called the Section 287G program. Ryan, could you tell us about that?
Sure. So there's a delegated authority from ICE to different state and local agencies to do certain things under what ICE normally would have the ability to do. And the chief one that I see come up is the holds that normally ICE is able to place on people who are non-citizens who are to be removed. That power in LA County is delegated to the Sheriff's Department under 287G, and there are a lot of different local agencies that have agreements to have this authority. In LA County, the agreement is basically that jailers at conviction, the way it's implemented in LA County is that if there's a conviction, there's an inmate in the jail, that person is screened for possibly being removable, and the specially trained officer from LA County Sheriff's Department can place a hold on that person. It's like a no-bail hold. They can't get out until that case is referred to the federal immigration authorities. And it's actually a pretty tame implementation of that program in LA County. There's a wide range of degrees of 287G. There's enforcement models where officers go out and they actually seek people who they suspect might be in violation of the immigration laws and try to get them deported. In LA County, it's a very limited model of detection. It's in the jails, and it's only upon conviction. And so that's where I see it implemented.
Thank you.
I was just going to note that I actually have an ICE representative that I dragged off his vacation day, Greg Williams. He's the supervising detention and deportation officer for basically the southern half of Oregon. Is that how that works? So do you have any experience with 287G programs here in Oregon? In California. Are there any jurisdictions who are implementing a 287G program in Oregon? No. Okay. Well, there you go.
So California is the only jurisdiction?
Oh, no. There are a bunch around the country.
Oh, I see. Okay.
But Oregon doesn't have any. Basically, there are limited ones, and the Department of Homeland Security will work with the governmental entity that wants, and it comes often with a stream of funding from the federal government.
I see. And so is it a matter of quantity that California, Arizona, or what?
And local support, and there's a lot of political.
I see.
What's that?
That's the key. Local support.
Thank you. That's interesting. So,
As a practical matter, in Oregon, or at least depending on the counties, in Washington County is a really good example. If you're pulled over for any reason whatsoever, you're going to get an ICE hold on you. That's just the way it works. In Washington, it's in Beaverton.
If they arrest you for
Yeah, I mean, if they arrest you, sorry, let me clarify that. If you get arrested for any reason, if you accidentally, and this is a real case, broke a window, you're going to get an ICE hold on you.
Now, what I haven't heard, and maybe you guys have some experience with this, do they in Washington County tend to book someone that they wouldn't otherwise book if they discover writing their name on the computer that they actually are subject to an ICE hold, or would be?
Yes. They do.
Well, I mean, I believe there's an ICE agent that works at
the
jail. I believe that there's an ICE agent assigned to that jail that does that
right.
check.
But as a matter of fact, I've had a number of clients who call me because they're arrested for a DUI or accidentally breaking a window, and because they don't have identification on them that shows they're here legally, they're taken to the police station where they normally would not be, and immigration is called, and they're just held until immigration comes.
looks like that's news to our ICE agents.
It's not quite that simple.
Well, if
under arrest, it's a requirement that the consulate be contacted if the person is admitted for national. All jails are required to ask every person coming into their facility, where were you born? And that's to include somebody that looks just like me. If I respond other than United States, that would activate the need to contact the consulate. That also then activates them to call ICE to say, hey, we have somebody who's admitted foreign birth. We don't know that he's legal or illegal. That's not for them to determine at that point. That's all that is done. They don't make that determination on the street. These are all arrestable offenses. So they've made an arrest. They brought him into the jail. Once lodged at the jail, that notification is made. It's not on the street level.
I could add a little bit. I think it's up to the police officer on the field. A lot of cases, he has, if it's a low-end case, he can just cite them and give them a citation to appear in court, or he can arrest them. And then once they're arrested, they're booked and processed like he's talking about, that's when the ICE agent or the contact with ICE comes into play. And it was not, a few years ago that ICE wouldn't pick them up. It just depended on what the charge was. I think we're being released, but now pretty much it's 100%, no matter what the charge is. If it's a low-end charge, that there's going to be an ICE hold. And there's a difference between picking them up and, what happens is when they're arrested, they're detained on the criminal charge, and then there's a hold from ICE. And then ICE just doesn't take them until the criminal charge is either completed or they're released. Either they bail out on the criminal charge and they're not being held on the local charge, and then they'll get them that way. So I think ICE will keep them. They're not going to act on it until the actual criminal charge itself is complete, and the local case is complete. That's been my experience is how it works. And so sometimes, it may be that ICE, they get released on the case and they're able to get released from ICE custody either in Portland or they go post a bond in Tacoma, and then the state case continues on. But that's a little tricky. But that's been my experience is the way it happens. But it's really discretionary on the officer out in the field whether he cites someone or arrests them at the jail. And I'm not sure if at the police station, I don't know. I haven't heard anything about that. I think it has to be at the actual jail itself where the ICE agents are located. So, that's just been my experience.
So I'd like to, we have just a little bit over 15 minutes, and I thought what I would do is ask each of you in turn, before I turn this over to a few minutes of questioning, kind of a bigger picture question, and that is, what do you see as the biggest issues in criminal law, in your experience, that relate to immigration status? And so I'm going to start with JJ here and just ask you to go down the line.
Well, I guess I'm going to be approaching this from an immigration lawyer's perspective. One of the biggest issues is that immigration law is very, very, very complicated. And so it's been difficult for criminal defense attorneys to be able to know what they can do and what they can't do and how things are going to be affected, because it's not like there's no simple rule. If you've got a misdemeanor, you're okay. If you've got a felony, you're in trouble. You have to go through a client's entire criminal history, from when they were born, how they got here, when they got here, how they got here, what their parents have green cards, their entire criminal history, and you have to do sort of a life story analysis to get to the point where you know what their actual situation is and what needs to be done, either to keep them from being deported completely or at least to be able to let them be eligible to apply for some sort of relief in front of the immigration judge. And so that's one issue. Things are just so complicated, it's hard for anybody to know what to do unless they have somebody who really, really knows this area look at the case. Another issue is that the law is changing enormously and constantly and every day, and there's a power struggle between the different courts. I don't know if anybody here has heard of Chevron deference, but there's a new case, Supreme Court, called Brand X, and the way things work, there's the immigration judge, and then they can be an appeal to the Board of Immigration Appeals, and then you go to a circuit court, and then up to the Supreme Court. And in light of this Brand X case, the Board of Immigration Appeals has taken the position that they can, in a lot of cases, overrule the circuit court. I mean, I'm sort of simplifying the description of it, but that's what they're saying. And so something that the Ninth Circuit Court had said, okay, this offense is not going to be considered a deportable offense, suddenly becomes a deportable offense. And all the people who had entered their pleas thinking that, okay, if I do this, I'm safe, suddenly they're not. There's no ex post facto. Most of the immigration laws are completely retroactive, so if somebody wasn't deportable at all 30 years ago, the law changes, now they're deportable and they're going to get deported.
As far as my experience is concerned, the biggest issue, it's not really an issue, but something that I always have to be very cognizant of in court handling cases on a day-to-day basis is the perception of fairness, and not so much being unfair to someone who's undocumented, because obviously a prosecutor is not going to do that on a general basis. It'd be completely inappropriate. What I'm referring to is some experiences that I've had where someone is facing some significant consequences that are collateral, like deportation, or I guess they're not collateral anymore, but it's a very severe consequence, obviously. But I don't want to consider that consequence when I'm looking at what the charges are and how I'm going to prove the case that this person violated a crime or violated a statute and constituted a crime. I had a case where there was a person who'd spent something like 25 years in California but wasn't a citizen, and he was subject to deportation. He was on probation for an assault, a felony assault, likely to cause great bodily injury. And while on probation, he offered to sell crack cocaine to an undercover officer. And the defense attorney came to me and he said, look, my guy's going to get deported. He can do probation in 364 days in county jail. I just can't go to prison. And I told him, he's looking at prison based on the probation case. And why am I supposed to give you a special deal because this guy is a non-citizen who might get deported? I mean, I understand why, and I appreciated him pointing out what the consequence was, and it's good to be cognizant of that. And that's important when looking at a full picture of a case, but it would be in effect punishing people who are citizens more for doing the same crime. And a lot of times to get a case to go away that might go to trial because of those consequences, sometimes You might get a judge who's receptive to that argument, might give someone a more lenient deal. I haven't seen that happen personally, but in this case, that defendant wound up admitting a violation of his probation. He took prison time, and we had problems with the cocaine case, so we actually dismissed that. But he probably got deported because assault's no better than selling cocaine. I'm not positive of that. Maybe you can clarify. If assault is a crime of moral turpitude that would result in automatic deportation, I certainly would hope so.
With 365 days, it becomes an aggravated felony.
Okay.
One of the Los Angeles has actually a better system than most counties. They actually have a policy in place that hardly anybody else does. In Clark County in Washington State, if the practice up there is to, if somebody commits any gross misdemeanor, punishable by a year or less, the court imposes the full 365 days and then suspends sentence. So, for example, I had a case where a guy was homeless. He went to a grocery store and he stole a cucumber because he was hungry. And the court, he was prosecuted. He was given 365 days suspended and let go. Because of that, he's what's called an aggravated felon, even though it's a misdemeanor. And the only way to avoid being deported if you've got an aggravated felony is essentially by showing that you would be tortured if you're returned to your home country.
Hard to follow that up. Oscar, biggest issue.
Well, I think that you're hitting it. It's just very complicated and the defense attorneys. I mean, we're not immigration lawyers. I have a basic knowledge, and we have to consult with them. And then the issue I see is, immigration lawyers aren't free. It's very difficult to get free advice, and it costs money. And then a lot of these people that are in trouble or don't have that money. So it's kind of frustrating sometimes. So I have some arrangements, some attorneys that I work with where they'll give me like an advisory letter if I put all the possible scenarios that are out there, and that really helps. But I just think that it's just very complicated. That I think it's very important that any defense lawyer definitely needs to consult with an immigration lawyer. And the problems where I see is, like in a lot of indigent cases at the state level, is that there's no funding. It's very limited, to get that funding. So I just think that, that's, especially if they have high caseloads, like in downtown Portland, where they're just going through cases. So it's very, very frustrating, I think. And I don't know, that's just, that's what I think is a real issue. So.
Thanks, Oscar. Ryan Bounds.
Well, I would just echo that. Particularly what Oscar said, having worked with federal public defenders, are usually the defense counsel for all of our federal cases in Oregon, and they have started getting non-federal public defender immigration experts to opine on their cases whenever there's a dispute about what a prior crime, whether it's an aggravated felony or something. So if there's a characterization issue, or if there's an issue about what relief from removal they either may have had at a prior removal stage, or what relief from removal they may have at the result of the pending criminal prosecution. And I think that we are probably headed in the general direction of requiring that degree of sophistication when you're representing an alien descendant. And as JJ said, that requires an enormous amount of sophistication. It's particularly when you start talking about benefits as opposed to the consequences of criminal convictions and penalties. The benefits, and like 212C and 212H and all sorts of stuff that's still bouncing around even though they've been repealed, it's very complicated. Having to look back to old versions of the INA, and you're having also to interpret constantly changing terms under the immigration statute. Congress is fiddling with it. The courts are constantly reinterpreting it. So the Ninth Circuit will say that something means something quite different from what every other circuit in the country says it means. And it's not just whether Johnny broke the window at the end of the day. It's a very complicated issue. I ask for Congress to act.
Right. Well, and with that, let me open this floor up for some questions. We have about 7 minutes. Meredith.
immigration fellow here mentioned something about consular notification when people are arrested and brought to the jail, and then they're asked, were you born in the U.S.? And the answer is no, and then there's an obligation to notify the consulate. Is that actually happening in your experience, and does it make any difference at all in terms of outcomes for undocumented?
Yes, it does happen. The jail in Washington County where I practice, they actually have it posted there, warnings, or in the booking area where you can see it. I was really surprised when I saw that. It was in English and Spanish. And it from a defending a case, it really doesn't do much. I mean, those rights aren't given. I can't suppress statements because of that, because it's U.S. wording law that applies. So it really doesn't do much in terms of the actual defense of the case itself.
What about the immigration part of it? Does the consulate offer help in any way in establishing some defense to removal?
I don't have an answer. I mean, I can tell you that, when people get arrested, they're just advised that they have this right, and either they can contact them or not. If somebody's arrested at 3 in the morning, I'm just not going to leave anything. So, but I can only tell you that it hasn't, in defending cases, when those issues have come up, I think there was some litigation on that, but it wasn't favorable, is that right? In terms of suppression of statements and certain things, I don't think it was very favorable.
I've pretty much only seen one client coming to me that actually got some assistance from a consulate.
I'm sorry, what?
I think I've only seen one client come into me who actually got assistance from a consulate.
Yes, Rosa.
I have a specific question about driver's license. I actually represent women in family law, and have clients who are without driver's license, keeping their kids to school, going grocery shopping. But if you are detained, you fail to stop at a red light or whatever, and you're here without entry, without inspection, you're obviously going to get charged without a license. So I'm kind of curious to see what your opinions are in terms of Oregon state law and the ability to get or not get driver's license. And do you feel, especially from the state and federal perspective, do you feel we're safer, or is the goal of the law being met? And then from your defense perspective, what is your opinion on that?
I'm glad you asked that question, just because this came up in the prior panel, and I was surprised that there's an Oregon bill pending to permit the licensure of unlawfully present aliens, and I was surprised by that because I thought that was inconsistent with the Real ID Act, and although I understand that Washington continues to flout the Real ID Act, Oregon has already implemented it, making it enormously painful for me to even update my driver's license. So I'm sympathetic, but as a policy matter, I see where you're coming from, and it would certainly be better to, if people are going to drive anyway, to at least expect some minimal level of competence and education about how to operate a car and all this sort of stuff, and you're not going to get that if they know ab initio they're not going to get a driver's license, they're not going to go in and take the test. However, I also understand the justification behind the Real ID Act, which is there's a significant national security concern with either fake licenses or licenses given to people who are not lawfully present and passing themselves off as citizens when they may not be. So it's a difficult question. All I know is it's expensive and painful to comply with. So, hence Washington's refusal so far, I think.
I've heard some just rumors about that DMV, Department of Motor Vehicles. The Department of Motor Vehicles is kind of hurting funding wise, with their fees are really down. So I don't know if it's a revenue generating or not. I really don't know, but that's what I've heard, that their fees, and I actually heard, whether it's true or not, but I think that, the people are still going to drive no matter what, they're going to be out there and they're not going to have a license and insurance. I don't know, it's really tough, so I think someone in the other panel said that's why, everybody's over in Washington now because they get their licenses,
So I think I'm going to take two hands, Mary, and then this hand here. So, Mary.
I was going to ask Oscar, do you put the advisal regarding immigration status, do you put that in your plea petition in written form?
Well, most plea petitions, and I actually brought one, and it's just a basic dialogue is what it is, where the judge will ask the person, and they really emphasize it, where it states, and this is pretty common in most counties, it's like, I understand if I am not a citizen of the United States, conviction of a crime may result under the law laws of the United States in my deportation, exclusion from admission into the United States, and denial of naturalization. Do you understand that? Yes. That's it. That's usually the dialogue we have. So I think that's more from my standpoint. My file will indicate that I had a conversation with my client, that he understood his rights, he understood what he had to do or not. So if that were to come back later where he or she would say, I didn't properly advise him, I've documented it in my file. So, but in terms of what happens in the plea petition, I mean, it's pretty limited to that. We don't want to say too much anyway about that stuff in the court documents. So, but that's basically what the judges ask, and do you understand that? And they say yes. On with the plea.
I have a request. Can we please use the word undocumented instead of alien or illegal person?